All right, I'm back again, and this is the last part of this, and we'll finish up. Now, additionally, you're going to see an essay in criminal law and procedure. Again, these cross over, they cross to evidence, they cross to professional responsibility, but look at your theft crimes, your robberies, your burglaries, and understand the degrees of them, your larcenies. Look at your theft crimes, and look at your search and seizures. So look under your Article 4 of your basic search and seizure items. And I don't think this should be too much for Crim Pro. Automobiles, exceptions, warrantless. You can search the car if you have probable cause. Basically, look at those warrantless exceptions, just your Article 4. I think that you should, in fact, be fine. And I think it should come in that basic area. Right. Now, next, that you have an essay that will be an inter vivos property style essay, and here you get either good domestic relations or real property, and I think you're going to see a good domestic relations question, and it'll focus on equitable distribution, and I think you're going to be happy with this question, and I think you're going to see it deals, just simply with those property rights. I can't negate a ground for divorce. They'll sue for an annulment because they defrauded them into marrying them. The trick here is that before they're married, they say they want kids, and after they're married, the husband says he doesn't, but he's changed his mind because remember, the fraud has to induce the marriage. So I think you could see an annulment style question, or maybe something else on grounds for divorce. But I think the thrust will be equitable distribution, and then it's going to cross over. So only a small part will be this domestic relations, and then there'll be someplace else in that essay, and it's never really possible to tell you how they mix these subjects together. And remember, the last big essay is going to be your EPTL essay. Here, look over your right of election. I think you'll see right of election in this question. But I am concerned that you could see a trust with creditors. And this is not a big deal. Don't go chase anything. This is just a creditor trying to get from the income beneficiary money. And we know when you create a trust for somebody else, it's automatically spendthrift. And as a spendthrift, it keeps the creditors from getting to the principal of that trust unless that beneficiary had control over it. But absent that, they just can get 10% of the income, or a special action can be brought to get any amount above 10% that's not needed for education support of the beneficiary or their family. It's not a big issue, but I am concerned that you could see actually a small rap issue. And so, not to be thrown off by it, but we've had some interesting cases, and the bars and the court always laughs at itself, and how little does anyone really understand this antiquated rule. But there are always easy questions in New York: a reduction of the age contingency, where you leave this until 35, and it would violate the 21 years, so we reduce it to 21 years, or just a simple issue: does the rule apply at all to this problem? And there's an interesting case. So a person has a option to purchase, and that option to purchase now is going to extend beyond a life and being plus 21 years. And the issue is, do options to purchase fall under the rule against perpetuities? And the answer is yes. It's a restraint on alienation. They do. So any option to purchase property has to be one that at the inception will occur within a life and being or 21 years, or could violate the rule against perpetuities. Pardon me. We had an interesting case with a option to renew a lease. Goes to the court, and the court now has to decide, does an option to renew a lease fall within the rule against perpetuities? And the answer is no. See, an option to renew a lease is not a restraint on alienation, that you can sell the property even though you have an option to renew, and if they don't renew, you're going to lease it to somebody else, and so that these aren't considered restraints on alienation. Now, Look, in looking at this overall exam and just looking at the few items that I've mentioned, none of this is meant to be chased. You are going to obviously not concentrate your study on these areas, but you're just going to make sure within your study you become familiar with them. You know that we can have many, many, many other little issues that can come up, up on the exam, and that with those other little issues, you should not, in fact, get thrown off. I mean, evidence, they're like hearsay, a business record exception, especially if it's a medical malpractice question, wouldn't be out of the way. The domestic violence questions where the cause of the harm comes in because it's really part of the medical record, those kind of questions. And so don't get thrown off with some crossovers into any other areas that when you deal with this, that you shouldn't really have any real problem with them. And again, you're not going to know everything on the exam. That what you're going to do is that you're going to just do your best. Now, there's no reason to call me about these predictions to ask me, do I have more or do I have other things to say? We have a limited amount of time and you need to put it to good use. And again, the focus is to be able to get points for the knowledge that you have. That's our basic focus. So remember, right? Don't focus now on what you don't know. Stay focused on what you do know and be confident that you know enough to succeed. All right, everybody, I wish you all good luck on the exam. I want you to call our office, right? Tell Emily that you did well, you feel confident. Of course, when you pass, we want to be in that group at the top, so we hear that you passed from yourself. We're excited for you. Do well, everyone. Pass the bar.